After the death of Bobby Lee Cook, I contacted criminal defense attorneys I consider to be among the all-time best. On this list is David Boies. David Boies represented Michael Moore in a federal investigation, and he's represented Theranos in an undetermined capacity. In this interview, Mr. Boies will discuss how to bleed a witness, especially one that is credible or sympathetic, and he'll also discuss the struggle that he's had with learning differences and how institutions have failed to accommodate those differences. Please enjoy the interview and please welcome the great David Boies. All right, I'm here with David Boies, the great David Boies. Mr. Boies, first question. So you pride yourself on taking controversial cases based on the principles they stand for. So why is this important? Why do you do this? Because it seems like you're maligned in the media a lot for doing this. It seems like you've been punished for doing this.
Well, I think a lot of lay people don't understand what lawyers do, don't understand the process of the law. There's a great tradition in American law that everybody deserves effective representation. Now, that doesn't mean that every lawyer has an obligation to take on every client. They don't. Lawyers have an opportunity to make judgments about the clients that they're going to represent. But what it does mean is that the profession as a whole needs to be sure that everybody has fair representation, whether we agree with them or disagree with them. John Adams famously represented the British soldiers who committed the Boston Massacre, not because he believed in them. Indeed, he was horrified at what had happened.
The mob that went after him, yeah.
Exactly, but he believed that you needed to have a rule of law. And to have a rule of law, you need to have, in our adversarial system, you need to have somebody representing both sides. And both sides have got to be adequately represented. And I think that one of the things that we sometimes lose sight of is the fact that that principle is fundamentally a principle that protects the more vulnerable in our society. For the most part.
Yes, it does.
But for the most part, the rich and powerful are always going to find representation. And for the most part, the rich and powerful.
They usually call you, in fact.
They call me or call somebody else who may also be a little expensive. So I think that they can pay for good lawyers, and they can pay for good PR people. The vulnerable have, and the less fortunate have less opportunity for that. And so I think we sometimes lose track of the fact that these principles, things like the right to counsel, presumption of innocence, due process, are fundamentally principles that have always been developed to protect the less powerful against the more powerful. Historically, sometimes it was the powerful against the more powerful, like the Magna Carta. People forget that the Magna Carta didn't have anything to do with ordinary citizens, but it only had to do with sort of protecting the lords against the king.
Powerful interests.
Powerful interests.
Divergence of the professional class from the, yep. Exactly. That'll do it. So you talk about how these same fundamental principles of our legal system, the fact that you use them to defend like wealthy clients is coincidental. It's incidental. It's because the principle on whole protects citizens regardless of how much money they make. So, for instance, the same someone off the street who has to go to a public defender, the right to counsel is, what would entitle that person to at least a defense, even if it's not a defense that the kind that they should get because of a lack of resources. Is that right?
I think that's right. Yeah. I also think that firms like ours that are profitable, well-financed firms, have an obligation to take on cases for clients that cannot afford counsel. For example, our firm from the beginning has made a commitment to pro bono work, and not just the pro bono work where you're representing an indigent defendant or somebody who needs help in housing court. We do those kinds of things. But also the kind of cases that involve tremendous resources. We represented a class of indigent children who were being deprived of adequate medical care in Florida. This case went on for 7 or 8 years. We devoted more than $10 million of fees to that case. Ultimately, were successful, but it was a very difficult case and one that no small firm could have afforded to do. And
establish new standard of care, right?
Exactly.
We really big accomplishment
in Florida, and that's helped people in Florida. It's also set a precedent for other states as well.
Yes.
So it was an important case to take on, but it was the kind of case that obviously the children didn't have the money to pay expensive lawyers.
Right.
And small firms really didn't have the resources to do it. So I think there's an important role for larger, more successful firms such as Boies to take these kind of cases on, so that you're not just using your resources to represent the people who can pay you, but you're also using your resources to represent the people who deserve representation, even though they can't afford it.
Okay. You have dyslexia.
Yes.
Yes. I never knew that about you before I began doing more research into you before the interview. I never knew that about you. I want to say that I think that is really admirable what you've accomplished. I've heard that it's very difficult. For you, it may not be difficult. It may just be different, a different way of learning rather than a bad way of learning. I kind of got that vibe from you. Is that right?
I think that's right. It's a difference. It's not necessarily a bad thing. It's a difficult thing when you're young. It's very difficult when you're young because it's not a processing problem. People who are dyslexic are not necessarily dumb.
No.
But what it is, it's an input problem. You don't input information. You don't read the same way most people read. And since our educational system is set up, understandably, to deal with the way most people read, for the dyslexic child, it can be very frustrating. And that frustration can lead to people just giving up. And that's one of the sad things about it is that it has its greatest effect at the time when you are most vulnerable, when you're in middle school, high school, adolescence.
Learning to read,
and where people are equating how you read with how smart you are. Now, as you get into college and law school, people equate how smart you are with how well you think, how well you analyze, how well you articulate. And those talents, people with dyslexia can have just like anybody else. So as you get older, dyslexia plays a smaller and smaller role in your life. But when you're young and vulnerable, it can be a hurdle.
I know for a fact that there are law students and lawyers just starting out with dyslexia, and they may be on the verge of, like you said, giving up. They may be really struggling. They may be practicing now, finding it very difficult. What do you say to somebody like that? What is your message to them? What do you say to motivate them?
One of the things I say is that it gets easier. The more you learn, the farther you progress in school, and the farther you progress in your practice, more and more what people are looking for you to do is give them judgment, give them representation. And you're going to be just as good at that, if not better, than people who read differently. You are going to be able to articulate, to think, to judge, to help them. How fast you read becomes less and less important the farther you progress. Um, Life is not a timed test. Um, we have a lot of time tests in school for some good and some bad reasons. But in life, you have the time to do what you need to do. If you read a little slower, that's okay, because you can take the time to do that. Um, and maybe you think a little faster. So in the end, as thinking becomes more important, uh, you're going to do just fine. I've seen I have 6 children. Two of them are dyslexic, um, and those two are also lawyers, um, and and they struggled when they were young, um, but now that they're practicing, um, nothing's holding them back. And I think that the lesson for people with dyslexia, and the lesson for the parents and teachers of people who have dyslexia, is that the most important approach is just patience, because it does get better. Um, you get enough data inputted as you grow older so that you can begin to use that, you begin to process that. And when you begin to get to that stage, um, you've got an even level playing field.
You are known as having a very good memory. And part of that, you've said, is the fact that your dyslexia actually helped you with that. You went to class and you sat and you listened, and you may have had a hard time with the reading the night before. You may not have gotten all the way through it, but you sat and you listened, and
Right.
you learned how to listen effectively, process. And that also comes in handy when you are cross-examining and when you are listening to the other side's direct. Would you like to say something about that?
Yeah, I think that listening is a really important trait that not very many people do very well. And I
Yeah.
think one of the things about having dyslexia is that you tend to have to listen. It teaches you to listen. Um, and that ability to listen becomes more and more important as you progress, and particularly if you're a trial lawyer, because the ability to listen, pick up things quickly, is critical in arguing to a court and responding to a court's questions, cross examining a witness. All of those kinds of steps are really, really critical to what you're doing. And what, um, in a way, uh, dyslexia forces you to learn to do things that are very valuable later on in life.
Throws you in the deep end. Yeah.
It throws you in the deep end, and you've got to learn to swim. And one of those things is listening. There's another one too,
What
which
is it?
is um, uh, I was in high school debate,
Oh, me
and
too.
in debate you have these cards that you. We used to have cards anyway. Maybe now that's all electronic.
Oh, we still got them. Yeah.
Uh, and uh, One of the things that I found is that because of my dyslexia, it was almost impossible for me to read from notes, because it took me too long to focus on the words on the note paper or the card. Um, and so I learned to speak extemporaneously, um, from an outline. Um, so today in court, um, I will rarely speak from notes or a script, and I will never read. Um, the one thing that you can be sure of is that a dyslexic lawyer is not going to fall into the trap of reading reading their presentation. And that technique, the ability to speak on your feet and think about it and speak extemporaneously, I've found to be a very valuable tool in the courtroom. It allows you to connect with a judge and a jury in a way that you can't if you're reading, and it's hard to do if you're sort of tied into your notes. So there are I wouldn't exactly wish dyslexia on anybody, but I think that there are a lot of positive things that come out of the dyslexic experience.
Yeah. Well, I think the other thing is I'm sure a lot of people with dyslexia, but also in general, maybe with could be depression, could be autism spectrum, anything like that,
Right,
are afraid to disclose this to employers.
right,
One of the benefits, well, with you, it doesn't matter. Anybody's going to hire you, whether you have dyslexia or not. Other people might feel that because there is a stigma, unfair as it is, against dyslexia, that some of the incorrect predispositions people have about it that you mentioned. Because of that, some people may feel like they can't tell others about it. They can't ask for help. And they certainly can't tell their employers about it,
right.
especially if they're applying for a job. What do you say on that front?
Well, I sympathize with that because I think there still is some stigma attached to uh, learning differences.
Hmm.
Um, and I think that we need to, as a society, recognize that those learning differences do not disqualify, should not disqualify anybody uh, from doing anything. Um, I'm probably too large to be a jockey, um, and I'm probably too small to be a professional football player. And there are certain things that you can't do no matter how much you'd like to do them. But in terms of being a lawyer, of working in society, there's a place for everybody. And I think that employers need to recognize that when they attach these kind of stigmas to learning differences, they're depriving themselves of some of the most valuable or potentially most valuable members of their workforce. And I think that more and more people are learning that. Um, I mean, Charles Schwab is dyslexic. He built one of the great financial institutions. Um, a lot of people, the CEO of major technological companies are dyslexic. Um, it is a trait that doesn't disqualify, and employers who recognize that, I think, are going to be the employers who are going to be benefited. And I think that as a society, we need to teach more. Um, uh, Sally Shaywitz at Yale has been a pioneer in helping people to understand dyslexia, understand what it is and what it is not, understand how to really profit from it. I think that she and others over the last few decades have made great progress in helping people to understand it. But I think we've got a long ways to go. And I think the employment area is one of the most critical. I think there are two areas. One is education, and the other is employment. Um, the educational system uh, needs to. It is beginning to. I think beginning to in important ways, um, but needs to understand that its function is to educate everybody, not just the majority, and that people who have learning differences need to be taught in a way that's consistent with those differences, and that'll profit everybody. That makes everybody better. And I think employers need to understand the same thing.
Thank you. No, that was very thoughtful. I appreciate that. And I hope that makes some difference if there's anyone listening to this with dyslexia or with um, learning difference of some kind. I hope that has made a difference. You defended, or rather, you represented Michael Moore in a federal investigation, and they were upset. His crime
Yes.
was taking some 9/11 firefighters who were involved in 9/11. They breathed
Yeah.
in all that smoke and gas and everything else, and he took them down to get health care to Cuba,
Right.
better health care than they could get here, more affordable. And they were going to crucify him for it. And you said no.
Right.
Why?
And
So tell me how you succeeded in that. They
sure.
never brought any charges, right?
No, no, they didn't.
Okay.
And I think we convinced them that A, it was the wrong thing to do, but B, it was probably also unconstitutional. Um, and I think that the combination of those two things ultimately convinced them not to do it. But um, if he had not had effective, strong representation, um, he would probably have been prosecuted. because they certainly indicated an intention to prosecute. And I took, and my firm took, tremendous heat, um, uh, publicity, politically, in the media for doing that. He was.
You got bad publicity for doing that?
We got a lot of bad publicity. People.
What did they say?
They said that we were traitors, that we were undermining the country, that we were supporting we were supporting Castro, that we were un-American, we were unpatriotic, and now we got a lot of people on our side too.
Yeah.
But I mean, I didn't get any death threats, although I have gotten death threats from cases.
Sure.
But I got a lot of really angry, emails with a lot of profane language describing what people thought of me. Because when you take on controversial cases, the people who don't like it tend to be louder than the people who like it. So if you only look at your inbox, you're going to find more people complaining than people thanking you. But I think if you take the longer view of what's the right role for a lawyer in our society, whether it's representing, Michael Moore, or representing somebody accused of terrorism. People deserve a representation, and we've got to provide that representation. And part of people's confidence in our justice system is, I think, that we give a just due process treatment to people who we despise, people who have done acts that we despise. We nevertheless give them due process, fair trial, representation, presumption of innocence. And that's true for people who do horrific things, both in terms of violence and abuse. I have, the last 6-8 years, I've represented a number of victims of a huge sex trafficking enterprise run by Jeffrey Epstein and Ghislaine Maxwell. And those individuals needed a long-term representation. And it was one that in the beginning, we were representing young, vulnerable people without much of a voice against some of the richest and most powerful people in the country. And if you just listened to people at the beginning, you would have thought that this was a terrible thing to be doing. I think people recognize the justice of it now. But I think that that process, that legal process, is critically important.
You actually represented one of the women who gave Dershowitz. Yeah. Okay. All right. You understand the question. I didn't know quite how to put that one. So okay. So you have this thing with Alan Dershowitz. All right. Lawyer for the Constitution. So he sues you. He sues you. You sued him eventually back, but only after he got you off the case where you were representing the woman who gave him a massage, right?
Yes, right.
Okay.
Yeah, so it was Virginia Giuffre. We were representing Virginia Giuffre, And we'd represented her for many years. We'd represented her suing Jeffrey Epstein, who Alan Dershowitz was the lawyer for Jeffrey Epstein.
Right.
And Virginia Giuffre had accused Alan Dershowitz of not only being Epstein's lawyer, but of participating in the sexual abuse. And uh, Alan Dershowitz was very, very public in his criticism of Virginia. He called her a lot of names. Um, he accused her of a lot of things. And that went on for a couple of years. And we tried to, by writing letters and the like, tried to get him to stop. We couldn't get him to stop. And so we eventually sued him on her behalf. And he didn't want to be sued by me. And he.
Why not?
Well, I think he
You think he's
didn't.
scared of you?
I don't think he wanted to be examined by me.
All right.
I think, and my firm, which is one of
I
my.
heard you got a few other good lawyers there.
Yeah, Sigurd McCauley, who's been key part of the representation of the Epstein victims, is a woman that no one would want to be cross-examined by. She's just a terrific lawyer, terrific trial lawyer, and very, very committed to this cause. He moved to disqualify us on the grounds that I was going to be a witness, and that was true. We did not think that required disqualification, particularly at the early stages. Or ordinarily, the rule of disqualifying a lawyer who's going to be a witness is to avoid the dual roles of a lawyer and a witness as an advocate and a testifier at trial. I think the better view, in my opinion, is that it doesn't apply to the pretrial phases. And I also thought that there was a good chance that my testimony wouldn't ever be required. However, we were disqualified. But he got
no judge wanted to preside over that. I'm sure.
That, but he be careful what you ask for. He disqualified Boies and Boies Schiller, but he got Chuck Cooper and Cooper
God.
Kirk. And so
he didn't do any better for himself.
He did not do himself.
No, he did not.
I think getting me off the case and Chuck Cooper on the case was not a positive development for Alan Dershowitz.
No, he ended in the same place he started. So let's see. So you're known for dressing in a professional but relatable way, kind of like you're dressed right now.
Yeah.
You wear your watch on the outside of your dress shirt.
That's right. Yeah.
I've seen that in so many pictures. Why do you do that?
Well, first of all, it's more comfortable there.
Okay, that makes sense. All right.
But most important, as you know, in court, it's important to keep track of your time.
Yes.
But you don't want to. Yeah. But you don't want to be sort of looking at your watch, in a way that sends a signal to the judge or the jury that you're impatient or you're bored or that you've got someplace else to be. And so you want to be able to do it in as unobtrusive way as possible. Now, in a lot of courts, they've got a clock, but sometimes the clock's behind you. So even in the courtrooms that have clocks, they're not always so visible. And you want to be able to check the time easily. And you can do it a lot better with a watch on the outside of your shirt than under your shirt. So I started doing that, I guess, more than 50 years ago.
I'm going to
Uh,
start doing it.
and
That's a great reason. Yeah.
but it works very well.
Yeah. Have you heard of Rusty Harden?
Yes, sure.
He
Yeah.
catches hell all the time for the way he dresses, and I don't understand what it is about the seems rather uptight of the law to that degree get down on somebody, because it's not like, I mean, he is and you both are eminent lawyers. You should be able to wear within reason what you want, right? You know, a
Right.
light colored suit. I mean, what's the harm?
Absolutely. I
Yeah.
agree completely. I mean,
Yeah.
you ought to wear what you're comfortable wearing, uh,
Yes.
because the most important thing when you're in court is for you to be comfortable in your skin, comfortable what you're doing. Um, if you're comfortable, that'll come across to the jury. If you're uncomfortable, that'll come across to the jury. And so, within reason, wear whatever it is makes you feel comfortable. Um, I know people who feel most comfortable if they're in a $2,000 suit, um, and I know people who feel they're most comfortable if they're in court with cowboy boots on,
I got some on right now.
and great, and that's the way you ought to that's the way you ought to dress.
Yeah.
Um, it's and remember, the jury are not fashion critics.
Correct.
Um, the jury is
Quite the
ordinary,
opposite.
or they're ordinary people. They wear all sorts of things, and they're not going to get down on you um, for what you wear, unless they think that um, what you're doing or how you're acting or what you're wearing is somehow uh, not real. Um, uh, I uh, if I went into court with a cowboy hat, it just wouldn't fit. Um, but I know a lot of lawyers who it does fit for, and for those lawyers who it fits for, no jury is going to get down on you for it. And I actually don't think juries get down on you. Sometimes lawyers will say, well, you don't want to go into jury trial wearing a expensive Rolex watch or something like that. I don't believe that. If you wear a Rolex watch most of the time, wear a Rolex watch in court. Juries know that you make money. They don't mind that. They mind if they think you're pretending that you don't. They mind if they think you're pretending something.
People didn't understand about Trump in some respects, that
That's
the
right.
working class folks, and that's, by the way, where you grew up, as did I.
Yes. Yeah.
And that it's that sometimes if people are like really, like sometimes Mitt Romney, I would see him just wearing a dress shirt. I'm like, yeah, I bet that dress shirt's worth like $500 or something like
Right.
that. You know what I mean? Like,
Yeah, exactly.
why not show it or whatever? That was the whole thing with Trump. I think, yeah, you're right. It applies to juries too.
Yeah.
So, let's see what else I got for you here. Right. So since the administration has changed, couldn't resist this. Since the
Right.
administration has changed, Alan Dershowitz has stepped down as lawyer for the Constitution. Will you
Right.
be stepping up in his place, or
Well, I don't think so.
you don't think so?
I think President Biden and Vice President Harris are very well staffed.
Uh,
One of
with
one of
some lawyers from your firm.
with some lawyers from my
Yeah.
firm, and
Congratulations. Yeah.
thanks, and a lot of other good lawyers. I mean,
Yes.
Ron Klain, who is
Yeah. Very fine lawyer.
uh, he's chief of staff. He's not
Yes.
really acting in a legal capacity, but he's a great lawyer,
Yes.
and I think one of the good things about the Biden administration is that they've got a really good group of people, including a really good group of lawyers, um, which is important. Um, People make a lot of lawyer jokes, but
I do.
lawyers, yeah, sometimes, but lawyers help keep an administration on track. A administration with good lawyers is going to do fewer bad things. And I think that we've seen that in history. I think President Trump would have been better served with some different lawyers.
Yes.
And I think a lawyer can play an important role in keeping, whether it's a chief executive of a corporation or the president of the United States, keeping them on track. And I think the better CEOs and the better presidents want to surround themselves with those kind of lawyers. Don't want to surround themselves just with people who are going to implement what they want to do, but surround themselves with lawyers who are going to exercise their judgment and really help them, keep on track.
Even if it means not prosecuting a case.
Even if it means not prosecuting a case. I think that's 100% right. Sometimes the most important decision that you make is not to do something.
Courageous. It takes a lot of courage as a prosecutor to dismiss a case because they'll be down your throat and they'll try to get you out. It's
no question about it.
Yeah.
And particularly if it's a popular case with a big constituency, the prosecutor that decides not to prosecute,
the next one will
takes a lot of heat.
In an instant where take the Smollett case in Chicago, where they dropped the charges, and now the judge appointed a special prosecutor and decided that they're gonna charge a case again.
Right.
It's not always a sure win.
No.
When you get So are you familiar with the Trial Lawyers Hall of Fame, Mr. Boies?
I'm not.
So the trial lawyer,
I should be.
You would think, right?
I'm not.
So the Trial Lawyers Hall of Fame, you can't represent corporations. I think that's one of the rules. So that may be why you haven't heard of it. But the Trial Lawyers Hall of Fame currently lists Clarence Darrow, and Clarence Darrow bribed juries. So I take this to mean that this is more of like, in terms of just raw trial skill, that they're making that assessment based on. F. Lee Bailey was disbarred, but nonetheless, he is one of the best lawyers there's ever been. I'm going to circulate a petition that says as much, that if they're going to keep St. Darrow which they will, as on the list of the Trial Lawyers Hall of Fame, that they should add F. Lee Bailey, because otherwise it's hypocritical. Do you have the courage to agree with me, Mr. Boies? Would you sign such a petition if it came your way?
I probably would, because I knew Lee Bailey. We never faced off against each other in court.
That would have been a show.
But we did face off once in a mock trial at the ABA convention in I think it was 1992. But it was a mock trial of Saddam Hussein, and I was the prosecutor and he was the defense lawyer, and he was a fine trial lawyer, and although Clarence Darrow wasn't disbarred, as you point out, he did bribe a jury, and he also represented corporations.
Yes.
So I think that I think Clarence Darrow deserves to be in the Trial Lawyers Hall of Fame, but I think Lee Bailey does too.
Well, thank you. I mean, I'm sure that's going to mean the world to him. I'll let him know. He'll see this.
Yeah.
So you defended you represented Weinstein.
Harvey Weinstein.
Yes, Harvey Weinstein. You hired this. Is it Black Cube? Is that what it's called?
The investigating firm is Black Cube.
Yes. So you hired Black Cube, most original name for an investigative firm. Right. Not really. You hire them, and they go after several people who have made accusations against Weinstein. This is not in any criminal capacity. This is in a civil capacity, right?
Yes,
Yeah.
I think there was. Uh, I think there was only one person they were investigating, but uh,
Oh,
they a woman by the name of Rose McGowan, um, who had made certain accusations against Mr. Weinstein that Mr. Weinstein denied, um, and uh, uh, the investigating firm was hired to find out what the facts were.
and you signed an agreement with them that said that they were to conduct themselves in an ethical way in conducting their investigations, and they didn't do that, and you
Right.
got blamed for it.
I think that's fair. And I think actually, um, I think it's fair uh, when a lawyer hires a firm, even though the firm promises that it's going to do everything uh, legally um, and above board, and it's got a lot of references, like you said, K&L Gates as their counsel. Um, Nevertheless, I do think a lawyer deserves criticism. I mean, if you're a baseball manager and you hire the wrong pitcher, um, even though you're not pitching, I think some of the criticism falls back on you, and I think that um, when you retain a firm, if they act badly, I think there's a certain fairness in the criticism. I think some of the criticism has um, uh, not been factual,
Right.
but
I
I
think
think
most of it, right? They're saying that you had hired them with the intention of having them go after and pursue this woman relentlessly, which never happened.
which didn't happen,
Yeah.
and there's things that said we hired them to go after the press, which didn't happen, which we did not do. That is, we did not
Right.
hire them to do that.
Did they go after the press though, even
Well,
without your authorization?
I think that probably the facts are that they did. Um,
Uh,
the uh, uh, A number of reporters have told me after the fact that they were contacted by representatives of Black Cube to try to get their sources and things like that. So I, I mean, I don't want to prejudge it because some of this is involved in litigation, but
sure, sure.
I would, I'd have to say that um, the the record looks to me from this standpoint that they did do some of that.
Okay.
Now,
Okay. Well,
I'm not saying they did anything illegal, but
sure, sure, of
uh,
course.
but I think there was stuff that we were not involved
Okay. Okay. So you believe again that is what you had hired them initially to do, to investigate ethically, that was fine. They
in.
carried it outside of the
I think lawyers do that all the time.
right,
Um, the
right.
uh, I got a certain amount of heat from the New York Times over this, but the New
I
York
see. Yeah,
Times hires investigators
you do.
to investigate people who sue them. Um, so I think that uh, one commentator said it would have been malpractice not to hire an investigator.
Correct. Yeah.
So I think that uh, I think it's entirely appropriate to hire investigators,
Yes.
but it's important that the investigators um, act ethically, and I think the lawyer bears a certain responsibility if the people that they've hired don't act properly, even if the lawyer did what they could to make sure that they acted within the law.
So it sounds like you are saying that you appreciate some of that criticism.
Yeah, I think some
Well,
of the
that's
criticism
excellent.
is
Yeah,
fair. I think some of the
that's
criticism,
good. Good.
um,
Okay. Well, that's excellent. Yeah. So you're saying that in order to be a good lawyer, sometimes you have to be receptive to um, accusations that you may have made a mistake.
Absolutely.
Yes. Okay.
Yeah, I mean,
Okay.
if you know, Willie Mays got into the Hall of Fame batting 330. I, I don't. I think hopefully we do better than that, but nobody's perfect,
Right.
um, and we make mistakes, um, and 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 sometimes even when you haven't made a mistake, something that you did um, ends up turning out badly. And in either situation, I think you have to take responsibility for that. One of the things that has happened to me many times is that I get a lot more credit than I deserve for something just because I'm the lead lawyer. Um, uh, the, um, the the work that we did on the marriage equality cases um, uh, 10 years ago um, uh, with Ted Olson. I mean, Ted and I got all the credit for that. In fact, there were dozens and dozens of lawyers who played really important roles. Um, and the lead lawyer always gets more credit than they deserve when things go well. And they always get more criticism than they deserve when things go badly. But that's um, part of life. And I think you need to accept that and understand that.
So, in that vein, then, with Bush v. Gore,
Yes.
um, it was obviously a political decision. You said that. I mean,
Yes.
pretty much everybody knows that by now.
Yes. Yes.
But I don't want to focus on that because, I mean, people can read about it if they want. What I want to focus on is you had the whole world watching you. This was the biggest, literally the biggest court case, that you could have asked for, um, you know, and you lost. Now,
Yeah.
granted, I think you lost for a foolish reason,
Right.
but you lost. And you said in an interview, you said before you had tried, before you went before the Supreme Court, you said, what do I have to lose? It's in other words, like, sure, losing's not the worst thing,
Right.
so I don't fear it. I'm going to do my best. And then afterward, you said, I lost the whole fucking country. Is what they
Right.
what they quoted. It's what they quoted you as saying
Right.
in the which I understand. I mean, it's a hell of a
Right.
thing. You went through quite an experience.
Yeah.
How did you get over that? Because I'm sure that everyone watching has already experienced professional failures and will again. How did you transcend that and still go on to win many cases afterward and do great work?
Well, to some extent, I'm still not over it. Um,
Right. Of
uh,
course. Of course. Yeah.
to some extent, I still think about it. Um, but I think one of the things that you have to do is you have to recognize that as a lawyer, you play a particular role in our justice system. Um, that is the role of an advocate. Um, and there is another person or persons um, playing a different role, and that's the judge. And the judge ultimately makes a decision between the two advocates. And you may think the judge's decision was wrong, as I do in Bush v. Gore, but you accept that decision because that's the process. That is what the rule of law depends on. It depends on having a process that is hopefully fair, but also having a process that when it comes to a conclusion, people accept it. And this was one of the most difficult decisions for me to accept. I actually had a more difficult decision early in my career. Um, but um, this was a very, very hard decision for me to accept. But ultimately, um, uh, I had to, and I had to move on. And one of the things that I think has helped is to see, I think, the recognition, not only among people in law schools, but among the courts themselves, that this was the wrong decision and should not be repeated.
So in that way, you feel to some extent vindicated, at least partially. in that way.
I think so, and I think you saw in this last election where a lot of people were asking the courts to intervene um, and stop vote counts or force states to count other votes. And the court said, no, we're not going to involve ourselves here. This is not something that the courts should be involved in. So I'm comforted by that. But I'm still not over it. I'm still not over
Understandably, and I can see, when you talk about it, I can see. I don't mean to point it out, but I can see it in your face that you're. It did leave its mark, but nonetheless, you are a great man, obviously, and you should know that you did the best you could, and that history, as you indicated, will judge you correctly. So. Theranos, the Theranos company, you represented both the company and the executive, the main, I believe the CEO.
Elizabeth Holmes.
Yes.
That's actually something that is right now being litigated
Right.
as to whether or not our representation was of Elizabeth Holmes. We represented
Oh.
Elizabeth Holmes in a couple of cases. But in the majority of the cases, the government is taking the position that we only represented the company. And it was the company to whom we sent the bills. It was the company that was named as the client in a lot of these cases. On the other hand, she was the chief executive officer and very much personified the company.
Yes.
And so there's right now there is a dispute in court as to whether my firm was representing both her personally and the company, or only the company and her in her capacity as chief executive of the company. That's important because of some privilege issues. That is, as to whether there are privilege documents that are the client's, that is the company's privilege, or were they also Elizabeth Holmes' privilege. So I don't want to intrude into that area. I think that's for the court to decide. But that's an issue.
I had no idea, upon asking the question, whether you represented, that it was that not even the courts had known whether you had. So yeah. So, but nonetheless, in your representation of either one,
Mm-hmm.
What do you think was central? What do you think that criminal defense lawyers can take from your representation of either Theranos or the executive?
I'm not sure that how much of that representation will be part of the criminal trial. I think that the extent to which it comes into the criminal trial, it probably comes in from the standpoint of the defense lawyers arguing the company was very well represented by large and sophisticated law firms. Um, um, we were one of three large law firms representing the company. Um, Wilmer Hale was representing the company. The Cooley firm was representing Elizabeth Holmes personally. Um, we were representing certainly the company and arguably Ms. Holmes as well. So I think the defense lawyers are going to be saying you had all these lawyers, and if none of those lawyers concluded that what Elizabeth Holmes was doing was fraudulent, it must not have been fraudulent. So I think that that's going to be, if I had to, sort of guess, that's the kind of way that our representation would come into the criminal case.
Okay, thank you. We have 10 minutes left. So the David Boies crash course on cross-examination. So you think you take a swing at it?
Sure. Take a swing.
Okay. All right. So principles of cross-examination. You say one of them is patience. One of the big ones is patience.
Yes.
You cross-examined a great general, General Westmoreland, who sued someone for libel.
CBS and Mike Wallace.
Ah.
CBS and Mike Wallace for libel.
And he was. Can you explain, like, not only, well, can you explain and contextualize the fact that he was a likable witness, and then talk about what you did, like what information you had, and then how you used that, and what principles were involved, I guess, in using those tactics?
I mean, Westmoreland was a career Army officer. He'd served his country his entire life. He looked like a general. He was, more than 6 feet. He was ramrod straight. He had a full head of gray hair, rugged face. And he was somebody who was obviously a patriot. He was somebody who I think the jury would start off admiring. And I was at that point considerably younger than I am now. And I thought that there was a grave danger that if I were to start off with a very aggressive cross-examination of him, it would turn the jury off. That they would feel I was not treating this person with the proper respect, and they would feel that I was being unfair to him, and that they would begin to develop sympathy for him. So what I had to do was I had to break down that image, but break it down in a soft way. Break it down so that the jurors came to the conclusion that there was a problem here before I pressed the idea that there was a problem here. And so what I would do is I started the cross-examination very respectfully. I'd been respectful in the opening statement. One of the things I said in the opening statement was this case was not about whether General Westmoreland was not a patriot. I said he was a patriot. I said it was, in fact, his patriotism that led him to do what he was criticized for, because he believed that we needed to win the Vietnam War. He believed we could win the Vietnam War. He believed that there was light at the end of the tunnel. But he was afraid that the public would not support the war and the public would abandon the war. And so he lied about how well they were doing. He misrepresented how many people of the enemy they were killing. He misrepresented how successful they were doing. And he wasn't doing that for any kind of selfish purpose. He didn't make any money out of it. He wasn't going to get a promotion out of it. He did it because he believed that this was the way to bring the country to the right decision. And
so briefly, sorry to cut you off, but briefly, this opening, to clarify, which when you talked about this in opening, this was one, your theory of the case, but it was also a way to prime the jury before cross that you weren't going to try to come down hard, right?
Exactly.
Okay, so just for the listeners. Okay, so go ahead. I'm sorry.
100% right. That's a great point. And so when I started cross-examination, in the beginning, I would say, now, General, you said this on your direct examination. Now, I have got a document here that on the surface looks like it's a little inconsistent with that. I'm sure there's an explanation, but I'd like you to give the jury what that explanation is. And he'd give an explanation, and then we'd go on to another point. And I would say, now, General, you said in your direct examination this, but in your deposition, you said this, and I put both of those up on a big board for the jury to compare them. And I would say, again, there's some difference here, and can you explain what that difference is? And his explanations weren't great, because what I was doing is I was showing him things that were really quite inconsistent. I just wasn't pointing out.
I bet you started with the most inconsistent stuff.
Stuff
that would be on its face, right?
On its face inconsistent, and on its face something that there wasn't an explanation for.
That's
And
genius.
so when I say, what's your explanation? Now he just sort of goes all over the map, trying to say something.
Squeeze
And
water from a stone. Yeah.
exactly, and you begin to, and the jury begins to wonder, well, that doesn't sound right. That doesn't really, it doesn't really sound. And sometimes he'd give an answer, and I'd say, General, I'm sorry, I just didn't understand that. Could you just explain that a little bit more? Because I'm not sure I understood exactly what you were saying. And the jury would be having the same thing. Listen, I don't understand that either. And as the jury began to have concerns about whether Westmoreland was really being um, as candid, then I could pick up the pace a little bit more. I could press him a little bit more, and uh, and uh, you know, finally, um, uh, I got to the point where um, I said to him, it was very important to you, wasn't it, General, that you convey to the American people and to the Congress and to the president that there was light at the end of the tunnel, that we were succeeding. He said, absolutely not, Mr. Boies. That's just not so. I never would have used those words. I didn't believe it. I didn't believe it. It was too uncertain. And so I never would have used those words. And I said, General, that's just not accurate, is it? You're not telling the jury what you really wrote back then, are you? And he got very exercised. And then, of course, I showed him a cable that he had written to his superior saying, I can now tell you
Okay.
that there is light at the end of the tunnel. Use those exact words. And uh, and uh, and that was a, a critical step in, I think, reaching the results that we reached.
I think he denied ever saying it because he thought that your use of light at the end of the tunnel was colloquial as opposed to an actual phrase from something that he said. That's very clever. So I'm guessing you personally read the document that came from.
Oh, yes.
So that's where preparation comes in.
Preparation.
To cross a witness. Yeah.
Absolutely.
There's 3 rules, right? Preparation, yeah.
Over and over, preparation, patience, preparation, patience, and preparation.
Yeah, there you go. Okay. All right.
And there's no substitute for
it.
You get a lot of opportunities in cross-examination to make a point. But if you're not prepared to make that point, you miss the opportunity.
What do you mean prepared? Like just in terms of what do you mean prepared to make the point? Done the necessary material?
Yeah, read the documents, understand everything that's in the document. When I tried the United States against Microsoft case, I personally read every word of every document that we offered in evidence. I read every deposition excerpt. Now, with dyslexia, that is slow. And it took me a long time to do it. But one of the advantages of reading slowly is you've got really good comprehension and you remember the stuff. By the time I had to actually go into court, I had a great reservoir of facts that I could pull out. The same thing was true when I took Bill Gates' deposition. I knew the facts. I knew the documents. I knew when he was being inconsistent.
They had prepared him well.
They had not prepared him well. I was surprised. I was really surprised.
When I said when I saw you had said that in a news article, I thought, really? Like you would think that the best of the best lawyers would have prepared him.
Yeah, he had all the money in the world for lawyers.
Yeah, I'll say. Yeah.
But I mean, and a lot of times, the richer and the more powerful you are, the harder it is to accept preparation. You think you know it all, and lawyers sometimes can try really hard to prepare a witness, and the witness just isn't taking the preparation.
Well, Mr. Boies, it looks like it's 4 o'clock. You've given me more time actually than I initially asked for, which I really appreciate. This has been one of the honors of my law school experience, here at Georgetown. And I just wanted to, from the bottom of my heart, thank you for your comments here. And I want you to know that I'm going to share this with the students of the Georgetown Defenders and with everyone else in my network. It was a pleasure to have you.
Well, thank you. It was a pleasure to be here. As you can tell, I love being a trial lawyer and I love talking about it.
I can tell. You take care, Mr. Boies.
Take care. You too. Bye.
Bye-bye.